talk, so let's go ahead and get this thing kicked off. Well, we good to go, Paul? Sorry, preemptively kick this off. Just for those of you in the room, we are recording this and also streaming it live to YouTube, so you'll be able to watch this later on if you miss anything. But we'll go ahead and commence. You probably met some of my staff out in the hallway. They'll be here afterwards and throughout to answer any questions. My name is Blake Bingham. I'm the Assistant State Engineer for the Division of Water Rights. I run the adjudication program. I'm the individual who sent those notices along with those summons out to you. And just to be clear right off the bat, I like to put this out front just so you understand that summons doesn't require your attendance at this public meeting tonight. So if at any time you feel like your curiosity's been satisfied, you don't have any more questions, or you just want to go somewhere else, feel free to stand up and make your way out, and we'll have some staff kind of direct you where you need to go. Also, if you have a burning question that's maybe specific to your situation, I'm happy to answer questions that are for the benefit of the group throughout the presentation, but if it's something that's maybe just specific to your own situation, again, I have staff out in the hallway who might be better suited to answer that while we continue with the presentation here, just so that everyone's time is not wasted worrying about someone's specific situation. It may not be applicable to everyone. So with that said, let's go ahead and get started. Here's the agenda for tonight, where we will talk about what an adjudication is, kind of go talk about some historical context of why we do this, why we are in your area, why you were receiving this notice at this time, talking about what a proposed determination is. That's another word that you'll hear often tonight and throughout this process. We'll talk about significant issues, the anticipated timelines, and then we'll answer any questions. Again, I'm happy to answer questions throughout the presentation. For those of you who may be viewing at home, there's an email address at the bottom of that slide. If you have a question that you come up with that you want answered, fire off an email to that email address, and at the conclusion of this presentation, I'll pull up my email and review any questions there so I can answer them also, again, for the benefit of the group. If you don't happen to get it fired off by the time we get to that point, that's fine. You can still shoot it to me and I'll still respond, or I'll have one of my staff respond to answer your question. And that goes for everyone here as well. That's kind of the generic email that all comes to me, but then I can just send it out to my individual staff members. And there will be additional contact information at the conclusion of this presentation as well. So usually when people receive this notice, a lot of them are probably not as conversant in water rights as maybe some are. And so I like to kind of start off with maybe a little general background, and kind of a water rights 101 as to what a water right is and what it is not, just to help clarify if there's any confusion out there. And so when we talk about a water right, we're talking about the right to divert from a natural source, such as a stream or an aquifer via a well, and beneficially use that water. And typically water rights have certain defining elements that they consist of. They have a defined nature of beneficial use, so what the water right's being used for, whether it's being used for irrigation, whether it's being used for stock watering, or whether it's for your domestic residence. You know, if you have a well piped into your house that you use for culinary water. There's a priority date which identifies where that water right falls in the list of the line of water rights as far as who gets their water first. So in Utah and throughout most of the West, we operate off of this doctrine of prior appropriation, which is kind of the first in time and first in right. So if you got your water right before someone else got theirs, you get all of yours before they get any of theirs. And that's just the way the system of priority works. And so to identify where your water right falls in that line, we have a priority date typically, and I'll talk a little bit more about that and where that came from. We have a defined quantity of use or of water, a flow rate. We typically measure that in cubic feet per second. The acronym for that is CFS, or by a volume, an annual volume such as an acre foot. And that's a kind of a strange unit for those of you who've not heard it, but if you can envision a property that's 1 acre and then have 1 foot in depth of water, that's the volume of water that we're describing when we talk about an acre foot. Water rights have a specified point of diversion. Again, this is just kind of a phrase used to identify where that water is being diverted from that natural source. So for underground points of diversion are wells, so the wells pulling the water out from the aquifer. For streams, that would be a head gate, or where the ditch connects with the stream. Or for a spring, it would be the spring box, okay? It has a specified place of beneficial use, and that's just really exactly what it sounds like. That's where it's being used. And we use the public land survey system to identify that by what we call aliquot parts or 40-acre tracts. Again, I don't want to get too wrapped around the axles, but part of the water right specifies where that water right can be used. So some of the thing, a question we get a lot when people receive this notice and this summons is they call us up and they say, well, I don't even know if I have a water right. And so really what we typically answer that is, well, do you have a well in your property? Do you have any ditches, any head gates? Are you diverting water, via head gate or any type of thing like that? Because those are sometimes the best evidence of whether there's a water right associated with your property or not. You can see that center picture. That's kind of a picture of what a head gate looks like. Again, if you have these on your property, you're probably really familiar with them because they take maintenance. You're often either renovating the well or making sure it's operating correctly, or you're cleaning out the head gate and getting it winterized and then getting it ready to go in the springtime as well. Okay, let's talk about what a water right isn't. It's not a share in an irrigation company, and this is something that's kind of it's hard, it's maybe a little bit counterintuitive, okay? So irrigation companies are kind of mutual benefit companies, right? People buy shares in those companies, shares of stock in those companies, and the companies own the water rights, and then they distribute the water based off those water rights to their shareholders. And so when you own a share in an irrigation company, it certainly is tied to a water right, but a share and a water right are not the same thing. And we often hear people curious as to whether they need to participate in this process if they have a share. And so that's something to be clear about what a share is and what a water right is, because sometimes people use those interchangeably when they shouldn't. But it's understandable why they do, right? So a share is obviously some ownership in an irrigation company or water company, and then the water company owns the rights and they're responsible for participating in this process. Does that mean that because you have a share you shouldn't participate? No. In fact, I would encourage you to participate and ensure that the board for that irrigation company is participating so that these rights are recognized that the company owns and manages. A water right is not a connection to your local municipality, okay? It's not. Now, again, those municipalities, they have water rights and they divert water and treat it and then send it down through the system into your individual connection, your water meter. And so, again, does that mean you shouldn't really worry about it? Well, probably don't need to, because generally these municipalities are very aware of this process. We work with them on a daily basis to ensure that they're participating and those rights are being recognized and being secured so they can deliver that water to the public, to their clients, or within their service area. So let's talk a little bit about historical context of why we do an adjudication. We've all heard the story, or probably aware that, in July of 1847, an advanced party of the Mormon pioneers entered the valley, and they started diverting the waters of City Creek to kind of soften up the ground and get a late season crop in. Bad joke. Then they built their shopping mall on top of it. Later that year, or the next year, Brigham Young made this kind of declaration that is kind of strikes at the essence of water, who owns water in Utah. And he said, there shall be no private ownership of the streams that come out of the canyons. They belong to the people, all the people. And that's really how Utah continues to operate, and that water is not really owned by the state. It's not owned by anyone. It's a public resource. And in order to use that resource, there's a system of permits that you have to go through to ensure that there's equity among the different water users. And so when we talk about water rights, the state doesn't own the water. No one owns the water. It's simply a public resource, a shared public resource. Well, between 1847 and 1850, the pioneer settlement that we now know as Utah kind of went from being a part of Mexico to this quasi-ecclesiastical state of Deseret and to the territory of Utah. However, because there was no real infrastructure, no political infrastructure, the government was church-centric. When I say church, I'm obviously referring to the LDS Church. Because diversions were from streams were kind of done on a communal basis. They were done to meet the immediate needs of the settlers. So settlers would be sent out to the various areas of what we now know as Utah. They start digging ditches and start conveying waters from these mountain streams to irrigate their lands. As a result of that, this doctrine of priority, I talked a little bit earlier about it, that it kind of evolved from that, where it would recognize the work and effort that the settlers, those initial settlers, had put into diverting that water, and then subsequent settlers would come around and still want to be able to irrigate their lands, and so they would get a secondary right. So you kind of had a primary right for those first settlers and a secondary right for subsequent settlers. Well, conflicts were often settled through ecclesiastical channels. Obviously, there wasn't any type of system in place at the time, so you had bishops' courts for, minor offenses, and if you didn't like what the bishop told you, then you would go to the stake high council, and they would make an ultimate decision. And there's an example I often cite, the Spanish Fork, the Spanish Fork River was decreed originally by a high council decision, an LDS Church high council decision, and that's still how that water is used. Basically, there's some subsequent decrees, but for the most part, that's how it operated, because there was a power vacuum. The church filled that vacuum. Well, in 1852, the First Territorial Legislative Assembly passed an ordinance that tried to remove the authority from the church and place it into the county courts, gave them the responsibility for issuing permits for timber and for water rights and those types of things. However, it was largely ignored. Salt Lake County was pretty much the only county where it may have gained some traction, but again, all throughout the state, settlers continued to divert water without really paying attention to that. And in any case, those county courts were elected officials, so the justices or those judges were elected, and you can imagine who the settlers were electing. They were electing their bishops and their stake presidents, so in fact, it was really not much different than it was under the previous system. Well, in 1877, the Desert Land Act was passed, and that was really intended by Congress to help settle the West. They wanted people to move out, to homestead the West. They just got this huge portion of land from Mexico, and they wanted to settle it. Well, some of the consequences of this act was that it delegated authority to the local territory or states to determine how water is appropriated. And some of us may think, well, that's obvious, that's something the states should do. Well, if you think about it, it's really not as obvious as you might expect, because they still had the government land office that would issue patents for land. So the federal government was still the ones saying, no, you can homestead this or you can homestead this, but they essentially deferred to the states to come up with laws that governed how water was appropriated and how that type of private property was issued to people. And it also had another consequence in that it severed the title of water from the land. So back east, where water is abundant, if you owned a piece of land adjacent to a stream or a river, you had this riparian right, where because you are adjacent to the stream, you could use the water, no issue. Well, obviously that doesn't work in the West. If you're trying to homestead lands that are far away from a creek, and one of the requirements of the Homestead Act was you had to irrigate. You had to irrigate and you had to develop the land. Well, you couldn't do that if you didn't live adjacent to a spring or a stream. And so one of the results was this kind of severed that relationship between land and water, and now you could divert water from these mountain streams and carry it long distances and use it on your own homestead. Well, in 1880, the 1852 law failed to really gain any traction, as I said, and so they tried another thing. They said, oh, well, what we're going to do is the executive branch is going to appoint these county selectmen, and they're going to determine who gets water rights and who doesn't. Eventually, it was overturned by the court, found unconstitutional, because you had the executive branch who was doling out property rights, which is kind of the domain of the justice system. Well, as a result, confusion continued to happen in spite of the best efforts of both the territorial legislature as well as the LDS Church. And the church continued to administer and decree water rights. Again, that 1879 High Council decision of the Spanish Fork River is a prime example of that. So in 1896, Utah gains statehood. And there was some controversy. There was people who were worried that the state was going to confiscate all the water rights. And you say, all right, no one has any rights to divert water. The state's going to gather them all up, and the state's going to own the water and then start issuing permits. And so there was some controversy over this. They decided, let's just not discuss water law at all. What we're going to do is we're just going to simply address it in one place in the Constitution, and we're going to recognize any existing rights that had been used up to that point. And so in Article 17 of the Utah Constitution, which is still there today, there's this phrase that all existing rights to the use of any of the waters in this state for any useful or beneficial purpose are hereby recognized and confirmed, meaning if you had used water up to that point, you could continue to do so without worrying about the state or someone else confiscating it. Well, in 1897, the Office of the State Engineer was created, and that's really the forerunner of the Division of Water Rights. So when I talk about the state engineer, that's really my boss. He's the executive director of the Division of Water Rights, kind of a historic title that's carried on through to this day. Well, his mission really had nothing to do with appropriating water rights. Really what he was asked to do or assigned to do was map the state, determine where these streams were, determine how large they were, what their capacity was, and pretty much just report the information to the legislature. Appropriations for water rights were still made by the old-fashioned way of going and pounding your claim in at the source and then go and recording that at the post office or the county recorder. And again, that was continued to be ignored. Well, in 1902, the United States Reclamation Service, what we now know as the Bureau of Reclamation, it was established, and it was given the mission of reclaiming the arid West. And they would do this by building gigantic reservoirs, all right? And they would do this throughout all of the West. But they were really reluctant to do this in any state that didn't have some type of comprehensive water law that allowed people to appropriate water rights or identify existing water rights. Because what they were worried about is they would go and build this project and then have no security to determine whether they actually had the water rights to fill the large reservoir. And we have a couple Bureau projects here in the state of Utah. So they are saying, all right, states, you're out of luck unless you have some type of water law that accounts for these old rights and accounts for new rights. So in 1903, the Utah State Legislature got the message, and they decided to pass the first comprehensive water law, which allowed for both adjudicating rights, recording all these existing rights, and then adjudicating to make sure they were current, as well as appropriating new rights. However, unfortunately, the system they set up failed to provide any funding to the courts to do that. And it was really kind of a bad system because they simply told the courts, hey, courts, it's your responsibility to figure out these old rights and to figure out what they constitute or how they are currently constituted. And in the judicial system, that doesn't really work because you really need, the judicial system is kind of an adversarial system. You need someone to bring a suit before the judge. The judge doesn't go out looking for ways to figure things out, right? People come to him and he makes some conclusions based on fact and law. And so really nothing ever happened. These old claims were never discovered. There were never any adjudicating of these existing rights. Well, in 1919, the legislature finally realized that, hey, we aren't getting ahead of this. We have all these old rights. No one knows what they are. People are continuing to use water without a water right. And so they provided the state engineer with the machinery to do that in the form of a proposed determination. And the proposed determination is really a fancy word for saying it's the state engineer's official recommendation to the court. So what happens now is the state engineer goes out, does a survey of all the water rights, identifies them, makes a recommendation based on his understanding of how the water rights should be administered, and then takes that to the court and says, all right, here's how we see it, and then they allow people to come in and say, no, the state engineer got it wrong, and then finally the court makes a decision on it. And we'll talk a lot about it. So that's kind of the process we still use today, and we'll talk a lot more in depth about what that means to you as water users and in its current format today. Well, and then also in 1935, so I should clarify, in 1903, that was the law governing surface water. after that, they still thought that you could still drill a well without a water right. They kind of had this idea that surface water was different than groundwater. Well, they finally realized that it's all the same water, that they are all hydrologically connected. And so the legislature passed a law in 1935 that said, well, if you want a well, if you need a water right for a well, you're going to have to get a water right. Prior to 1935, you could drill a well without a water right and divert from that aquifer. So finally, in 1935, we kind of have this concept that, hey, you need a water right, whether it's from a surface source or from a groundwater source. So prior to the enactment of that 1903 law, water rights kind of fell into one of several different categories. You had those that were decreed by ecclesiastical leaders, whether the bishop or the high council said, oh, you have a right and you don't. You had those. You had those that were filed for record at the county court or the county recorder's office. Those that were decreed by a court, but those were only suits that were brought before the judge, so they were limited parties. So if I didn't like this guy's water right, he didn't like mine, we go and we fight it out, and the court would make a decision between me and him, but it affected no one else. It didn't affect my rights with respect to your rights. It just affected our rights to each other. So it was limited in the number of parties who participated. Also, there are these contractual agreements among different parties, and there's a lot of those in the Salt Lake Valley, specifically with Salt Lake City and some of these early canal companies, because Salt Lake City obviously wanted the clean canyon water because both it's higher up in the system and it's easier to treat and it's more palatable for a culinary system. So they made these exchange agreements. So there are a lot of those. And then you had those claims that never manifested themselves on any records at all. These are the people that continue to divert water. Remember, they were diverting water prior to 1903 for surface water, or they had a well prior to 1935, and they were just fine. They didn't feel like they needed a water right. Well, these guys continue to divert water to this day without having a water right. As a result, there was a number of issues. First of all, there was no public record of water rights. There certainly wasn't any consolidated public record. You couldn't go to one place and find what the water rights situation was for any particular part of the state. You could certainly try to go to the county recorder, but they would probably look at you with vacant gaze, wondering what you're talking about with water rights, even though there may have been some type of water right filed there back in the 30s or 20s or something to that effect. Since there was no record, over-appropriation was rampant. There was a lot of court decrees that decreed more water than was actually physically possible in the stream itself. And because rights weren't defined, they came into controversy and had to be settled through those ecclesiastical or those court channels. In his biennial report near the turn of the century, the state engineer at the time made the following observation. So keep in mind, this is before we had a comprehensive water law. We had all these old existing water rights. And so he's really concerned about this. He said, the definition of existing rights appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made of public record. So his idea is like, hey, we need to go and find out what all these old existing rights are before we can start appropriating new rights. Well, as I pointed out earlier, the legislature failed to really give the machinery to the state engineer to do that, so they started appropriating rights anyways because there was a demand to continue to develop these sources. And so you had these old rights and you had new rights, and you have these two different processes, the appropriation process and the adjudication process going in parallel, and it's much like what we do today. However, the appropriation process had a head start, and the adjudication process kind of languished for a while for various reasons that I'll cover here in a bit. So what is a general stream adjudication? Well, as its name implies, it's an action in court. It's actually an action in state district court. It binds all water users, not just a limited number of water users, but all the water users in the drainage, including the state engineer. That's the title of code it's governed by. Title 73. And the first general stream adjudications took place in the 20s. You recall that machinery of the proposed determination didn't come around until 1919. So the initial adjudications took place in the 20s, and it's kind of hard to see, but some of the initial adjudications include the Weber River drainage, the severe river drainage, and even the virgin river drainage. But you'll notice that all of these other ones are also, those are what we consider general adjudications. And when we talk about the West Murray Subdivision of the Utah Lake Jordan River general adjudication, we're talking about this big purple blob right here, okay? That's the Utah Lake general adjudication. And we're just doing a bite-sized portion of it because it's huge. And there are a lot of water users, and so we kind of have to eat the elephant one bite at a time. And you'll know, you probably can't see, but a lot of these were started in the 20s, but a lot of them were started in the 50s, and that's because of a concept called federal reserved water rights and the McCarran Amendment. Again, I'll cover that here in a short instant. But the bottom line is, throughout the state of Utah, there are these general adjudications taking place, all right? The Weber drainage, we've buttoned that up, so we're not really doing anything there. Same thing with the severe. The Virgin River, they've asked us to come back and do it again because there was some confusion from the previous time around. So why do we conduct general adjudications? Well, we want to bring all claims onto the permanent record. You remember this guy who's diverting water without a water right? Because the state constitution provided for it and the state law allowed for it. He had what we call pre-statutory rights, or he has a water right prior to the law establishing that water right. So for surface rights, that's 1903. For underground water rights, that's 1935. Then you have these federal reserved water rights, and this is kind of a whole different ballgame, right? It stems from a court case, a Supreme Court case at the turn of the century. There was the Fort Belknap Indian Reservation along the Milk River, and you'll recall that the Desert Land Act essentially told the states, hey, it's up to you how to appropriate these water rights. Well, they formed this reservation, but when the Indians went to go and get some water from the Milk River to kind of till the ground and kind of develop it, the state engineer or the equivalent there said, well, sorry, the Milk River has all been appropriated. You're out of luck. We've already given all the water rights to all these other settlers around the Indian reservation, so tough luck, Chuck, right? And so the Indians, or the federal government, or excuse me, they took suit and sued the state of Montana, took it to the Supreme Court, and the Supreme Court, in essence, said, by virtue of the fact that Congress has reserved this Indian reservation from the public domain and given the Indians this task to do, become kind of a civilized agricultural people, there was an implied water right with that. And the implied water right had the priority date equal to the reservation. Well, that was great. Obviously, it's a good thing. They shouldn't be making reservations, especially Indian reservations, without giving them the means to function as they are intended. Well, that policy, or that doctrine, called the Winters Doctrine, was subsequently applied to other types of federal reservations, such as national parks, Forest Service reservations, national monuments. So you can see where I'm going with this. We're in the state of Utah, where about roughly 70% of our land is owned by the federal government. We have a lot of these federal inholdings. We not only have Indian reservations, but we have a lot of Forest Service ground. We have a lot of national parks. We have a lot of national monuments. But the problem was we couldn't do anything about it because you can't sue the federal government unless the federal government allows you to, right? They have this thing called federal sovereign immunity. Well, McCarran was a senator from Nevada, and he didn't think that was fair, and obviously it's not fair. When states are trying to appropriate water rights and they have this cloud of these unknown Federal Reserve water rights that can't be quantified, we can't force the federal government to quantify them, he ran a bill which is now known as the McCarran Amendment, which in essence says the federal government waives its federal sovereign immunity with respect to water rights when it comes to general adjudications or water right adjudications. And so in essence, the state of Utah can join the federal government and force them via this amendment to quantify their water rights through a general adjudication. And so a lot of those, you remember those other colorful areas in the state, those are all instituted after 1952 because the state of Utah said, hey, well, yeah, we ought to do this because there's a lot of federal inholdings that we need to determine what those water rights are. And so it not only waives their sovereign immunity, it also makes them do it in a state district court, which is really unique. Not a lot of court cases or suits against the federal government end up in state district court. I can't think of any to be honest with you. But this is unique. The federal government has to participate. They have to quantify their claims, and they have to do it they have to be subject to the state district court. So that's another reason why general adjudications are important, especially in the West. Another reason why we do them is to prevent a multiplicity of suits and to bring clarity to the water rights picture. Again, we don't want everyone suing each other. We just want to do it in one big suit and have it apply to everyone. Another thing, and this may be kind of the more controversial aspect of this, is that we want to remove or reduce any water rights that have long since been abandoned. And so these are water rights that may have been appropriated a long time ago, and they've been stopped being used. In Utah, it's 7 years. If you haven't used your water right in 7 years, it reverts back to the public, otherwise known as forfeiture or abandonment. Again, this is the more controversial aspect. This is probably where I get the most, concerted arguments about, how can the state do that? And I can completely agree, I can understand, but if you kind of flip the argument and take it from the point of view of water users, right? If someone has failed to use their water right for 20 years, 7 years, whatever, that water is continuing to go downstream, and it's being used by someone. And whole communities have been built up on that water being available. So if you kind of look at it in that fashion, that, entire communities have become reliant on that water, and if you were to suddenly say, oh, I'm back, I'm going to use this water that I haven't used in 50 years, well, suddenly that leaves these people who have relied on that water, puts them in a terrible position. So that was really the intent of that law, and it's really common throughout all the West. There's some type of use it or lose it law in place to avoid monopolies and to ensure that the beneficial use of the water is put to its best use. And finally, we want to get a comprehensive decree on all water rights within this respective drainage. You guys have been really quiet. Usually what happens is someone asks a question and the floodgates unleash, right? Again, feel free to ask any questions at any point, and we'll see where we go. So let's talk a bit about the adjudication process. It's kind of a 3-phase process. And I'll go into these a little bit more in depth and kind of give you an idea of what the next expectation from you is, so that you can know what to expect here in the next few weeks and how this is going to kind of unfold. Well, if you look at the green, we're at the end of the number 4, right? The end of the green phase, where the petition was actually happened back in 1936. The Utah Lake Jordan River General Adjudication, I think, is the oldest ongoing civil course in this civil case in the state of Utah. So this started in 1936 because of a horrific drought, and there was a need to identify who owned what water rights because there wasn't enough water to go around, and it got turned into a general adjudication. Well, we sent out notice. We've published notice, step number 2 in the newspaper, and then we've issued summons. We will also issue summons in the newspaper. Isn't that what you receive? And then, of course, we're doing step number 4 tonight, doing the public meeting. The next step will be a notice to submit claims, in which you'll have 90 days to file a claim, and we'll talk about what that claim will look like and how to do that and what's the expectation there. Those water rights of record. So when I talk about water rights of record, I'm referring to upstairs in our offices. There's an entire file room, about half the size of this room, that has nothing but water right files in it, okay? And so these are water rights that we know of. We call those water rights of record. This isn't the Dos Equis guy, he's the water right not of record, or not of record, all right? These are the ones that we know of that have been appropriated, have been claimed. So if there are water rights within that area where people fail to file a claim, those will go on this list of unclaimed rights. And we will, again, send notice of that to everyone. People have 90 days to object. If they see their water right on there and it shouldn't have been on there, they'll have an opportunity to say no. We'll have a public meeting. Those water rights that are on the list of unclaimed rights will in essence be abandoned. So people who fail to claim those water rights, the judicial system will simply say, all right, by virtue of the fact that they failed to show up to claim them, we're just going to do away with them because we want to clean up the record, okay? Again, we'll get into a little bit more detail on that. After you guys have filed your claim, we'll investigate the claim. I have some boots on the ground staff that will come out, meet with you, look at your well, and validate your claim. Then we get all those claims and we compile them into the proposed determination. We kind of do a recommendation. We put them in one book. Again, we send notice out, and we have a public meeting. If you don't like how we've recommended it to the court, you have an opportunity to object, and we have to resolve those objections before we can get a decree from the court. So that's kind of the broad overview, kind of the East Coast to West Coast synopsis, all right? Let's get a little bit more in the weeds so you understand what's going to happen here in the next few weeks. So let's talk about filing your water user's claim. So March 30th, I believe, is the date when we will mail out a notice to file claims. With that notice will be the actual water user's claim form. So we will mail this notice to you, and we'll also publish it in the newspaper. So in that packet, depending if you are a property owner, so one thing I didn't say is we've sent this notice to all property owners within this area that you see in the map on that notice, all right? We do that just because we don't want to miss anybody. If there are people who have a right not of record, remember the Dos Equis guy, we want to make sure he comes forward and submits his claim. So that's why we've sent notice to all the property owners. So if you are a property owner, we will send you the notice with a blank claim. It'll just be a standard claim form, and you'll look at it, you'll scratch your head, and you probably, unless you've dealt in water rights, won't really know what to do with it. But we're here to help you fill that out. Now, if you're a water right owner of record, meaning you're on our records up here, and we have a water right with your name on it, we'll send you the notice, and we'll send you the claim already filled out with the information we have on our records. And all you need to do, if you want to make revisions to that or whatever, sign that claim, and then you can file it with us, or you can file it with the district court, okay? However, you'll have 90 days from the date of that notice, so March 30th. 90 days from March 30th is June 28th, okay? So you'll have 90 days to file that claim with us or with the court. Once we receive the claim, we'll attempt to make contact with the individual who's made the claim so we can come out and investigate it. And really all we're doing is just verifying, is keeping the honest people honest, right? If you have a well and you're using it, we want to see that. We want to see that, in fact, the well is there, that there is a way to irrigate, or that it is running to your house, those types of things. So it'll just be kind of a casual field visit. It won't take too long unless you have some complicated systems. And then we will make a recommendation. Well, let me back up. So you remember the pile or the file room of records up here. You recall that I said that there are those that we will send out to people who are water right owners of record. Now, if those claims, if no one files a claim for those water rights of record, they get put on this list of unclaimed rights. So they have 90 days to file those rights of record, or those claims for us for those rights of record. And if they fail to do it, then they'll go on this list. And it's simply a list that have the owner's name, has the location, the point of diversion, okay? And it really, and then the water right number. And so that list will go out to everyone. The notice for that list will go to all the property owners that receive notice of this. And we'll have a public meeting. We'll kind of go through what the list of unclaimed rights looks like. It'll be similar to this, except only maybe one or two people will actually show up to that meeting based on previous experience. But we will still hold the public meeting to explain that process to them. If you are a claimant or a water right owner of record, and you say, no, that's my water right, it shouldn't be on the list of unclaimed rights, you have 90 days to file an objection, but you have to file that objection, since it's a legal proceeding now, you have to file that at the court. Again, we can show you how to do that. We can't do it for you, but we can at least kind of give you an azimuth and pace count and tell you that's what you need to do, and that's how it gets done. And then you also have to file a water user's claim at that time with us. Yes, sir.
Sorry.
Yeah, you're absolutely fine.
So if you had a water right before and it was sold, you still up there as the water right owner? Because we had water rights before and the company shut down. Are we still in that file room?
That's a good question. So let me repeat your questions for the benefit of the rest of the group here. So he's asking if you had a water right before and you have since then sold that water right, whose name is on that water right in our records up here? And that's the answer to that is it depends. Usually what happens is when you can convey water rights either by selling them, or sometimes, usually what happens is people sell the property that the water rights are associated with. So there's two different instances. Let me cover the first one first, where you talk about selling your water right. Well, it depends on what name we have up there, because even though you've sold that water right, that doesn't automatically register with us, right? Like when you sell your car, the DMV doesn't automatically know who you sold the car to until you register it with the DMV. So it's a similar concept that you need to, there's a form that you do to update your ownership on our records. So we may have old ownership data on a lot of those rights, and I guarantee you we do for most of them, for not most of them, but a good portion of them. Now let's talk about the concept of a water right being sold with the property. So in Utah, it's assumed that water rights transfer with the land unless they're explicitly withheld. So if I'm selling my land to you, and I'm silent on my deed conveying the land with respect to water rights, it's assumed that the water rights that were associated with that land also went with you with the land. Again, you can see the problem is that sometimes people who receive the land and maybe not very don't understand the concept of water rights and just see a well in their backyard, they don't even know that there's a water right associated with that. And they certainly don't know that there's probably something on our records up here that had the previous owners, or even 3 previous owners back, their name on that water right in order to drill that well. And that's really common in Salt Lake Valley, where initially a lot of homes drilled wells and hooked their homes up to it because there was no culinary service. Salt Lake City or whatever municipality or public water supplier hadn't extended their service boundaries that far yet. And so a lot of people had older homes, they just had drilled a well, and that's how they got their water. Well, as time goes on and they get water supplied by these public water suppliers, by these municipalities, what happens is they connect to that, and then they disconnect their well, but they still use their well to irrigate their garden or something to that effect. And so a lot of the time people don't understand that, again, new generation comes in, new homeowner, they don't understand there's a water right with that well, and we still have the homeowner's name on it that was originally appropriated back in the 40s, okay? And that's very common, especially in this area, okay? Does that kind of answer your question? So it's not automatic that our records are up to date. There's actually a process that gets them up to date. It's called a report of conveyance, a title report of conveyance, where you have to chase that chain of title from the original appropriator through the land ownership deeds to the now current owner. But that shouldn't prevent you from participating. How do you know? We can look on our records. So I'm going to show everyone, we have an interface, like a map interface, that will show where these wells are located, and it's based on aerial imagery, and you can say, well, that's my house, and I think that's my well, and we'll pull it up, and it'll say who is the owner of record on it. So we can come to a pretty good conclusion, assuming that that's the correct water right. So, and I'll show everyone afterwards. I'll walk them through our website to show them the things that they can do and look at that. Oh, yes, sorry.
Just a point of clarification, because I want to make sure I'm understanding.
Sure.
It sounds like right now you're talking about water rights as they're connected with land ownership. But for those of us that have water shares, then shouldn't the party defending that, shouldn't that revert to the president of the water company and or the company's attorney? I don't think they're here tonight, but shouldn't they be duking this out?
That's a great question. Let me just repeat it for us. And it kind of goes back to what we talked about, the difference between water shares and water rights. Her question, or her point was that, we've talked a lot, or I've been talking a lot about private ownership of water rights. However, there's probably some shareholders in here and some irrigation company, or even a municipal type company, a water company of some variety. What are their responsibilities? Shouldn't it be the responsibility of the company itself to participate? And the answer is yes, because they would be the owners of record for those water rights. Whether it's, where I live, it's the Huntsville Waterworks Company that owns the irrigation water rights. I'm a shareholder, I own shares, but it's the company and their attorney that have to participate in this process. So does that mean that you should just sit idly back and wait for them to do something? I would just caution you against that. Obviously, be engaged and make sure that the company is pursuing that. For the most part, I believe companies are on top of this, but there are a lot of companies that have limited resources and may not be as proficient in this, especially some of these older companies that are kind of dwindling in water users as the place becomes more urban. So, good point. Thank you. Any other questions? Should we drive on? Keep driving? All right. So, the list of unclaimed rights. Again, you'll have 90 days from the notice to file an objection with the court. You need to also file a water user's claim with us at that time. We are obligated to resolve those objections before we can move forward. So before they become officially abandoned by the court, we have to, at the state engineer's office, resolve those objections. Usually for the list of unclaimed rights, we just say, all right, you missed the opportunity to file a claim, file your claim, let's move on. And we'll just look at it in the proposed determination process. So it's not hugely controversial. We really want people to file their claim. We're not trying to prevent people from doing that. We want people to participate. We don't want people to abuse the system, but we want people to participate. Once those objections are resolved, the list of unclaimed rights will be decreed by the court, and those rights on the list, those rights on the list will become abandoned. That must have timed out on me. There we go. I think we're back in business. All right. The court will, in essence, say that those rights are abandoned. And what that means is they don't go to somebody. They don't, we don't put them in our pockets and use them for somewhere else. They just become ineffective. You can't use them anymore. They're void, okay? We'll keep them in our records upstairs in paper format, but in essence, that's just for historical purposes. Another thing that's significant about that decree, yes, ma'am.
Can someone buy that water right once it's done?
You bet. You can buy oceanfront land in Nevada if you want. I wouldn't recommend doing it because it's not worth anything. I mean, people will sell it to you. Would I recommend buying it? No, because there's no way to. There's nothing for it. There's nothing, right? But go for it if you want to buy one. More power to you. More power to whoever's selling it to you is really what I mean. Yes, sir.
If there's a physical well with an unclaimed water right, what happens to that?
If there's a physical well, what happens to that? That's a good question. We at the state engineer's office, we're not interested in being the secret police and going around and making enforcement actions or anything like that. We do have an enforcement section, but it's not really worried. So we're not going to come around and say, hey, you have a well, but you have an abandoned water right, you need to cap that and plug that. Does that mean that your neighbor, if you ever get in a conflict with him and he understands the status of that well and he rats you out and then we have to come and do this? To be quite frank, there's more water issues than a well in a backyard for us to worry about. So we don't come out and seal it or cap it or anything like that. It's just right goes away. And people, will probably continue to use that well is my guess. They'll just do so without a water right, and they'll be breaking the law. So I guess you have a guilty conscience and you have to deal with that later. Sir?
Hey, so what if you had a lot of water right, our well used to water cattle, if you had a stock, and we don't have the cows anymore, do we lose quantity in that?
That's a great question. So in this gentleman's scenario he's painting is he has a lot of cattle at one time. I mean, he had a water rights associated with that cattle. He doesn't currently have any cattle. Do we look at that and do we trim him back? The answer is yes and no. So here's kind of the long and short of it, okay? We come out and we look for the beneficial uses associated with the water right. If there aren't, so if you had let's just use irrigation because it's easily quantify and it applies to stock as well, okay? If you had a 10-acre irrigation water right, so you had a water right that irrigated 10 acres and now you're only irrigating 5 acres, we would only be able to recognize 5 acres. So your water right would be reduced by whatever you're not using it, because we want to make sure that water that's being used elsewhere. Now, the one caveat to that is what we see a lot of is, as I said before, these domestic water rights that are no longer used for the house, but they're now using them for irrigation. Well, there's a Utah Supreme Court case law out there that in essence says, even though it's unauthorized use, it still protects it from forfeiture. So if you're using that water that was once used for stock, but you're using it for irrigation now, we would still recognize it as the stock, and we put a little note on our recommendation saying a change application needs to be filed, but we wouldn't reduce it as long as the use associated with that unauthorized use is equivalent to whatever right you had. And that happens mostly with people who had domestic components to their water rights but aren't using that anymore, but they use it for irrigation. And so in previous proposed determinations, if you ever want to look them up, you'll see a lot of water rights with that type of note that said, this water right is authorized for one domestic unit. However, when a field evaluation was conducted, irrigation was observed, a change application has not been filed in conformance with Utah law. That's the essence of the comment. But it preserves the water, right? Because the Supreme Court has said, even though it's illegal use, it's still being beneficially used, therefore it's not subject to forfeiture. Sorry for the legal technicalities, but that kind of gives you the sideboards of what we're talking about, so the expectations. And again, we try to facilitate that because, again, we're not interested in people losing their water rights. One other consequence of the judicial decree in this point is this would bar any more claims being filed. So remember the Dos Equis guy who had a claim that he didn't want to bring forward? Well, if he failed to do that at this point, he would not be able to bring that forward any further, and he would not have a water right. He would not be able to use that water that he had been enjoying up to that point. And that's a way of cleaning these things up. So it's kind of people's incentive to participate, including the Dos Equis guy. All right, let's keep on driving. Maybe. There we go. All right, proposed determination. So we will go out and evaluate these claims, and then we'll come back and we'll compare the claims with what we know the water rights is on the records. Or we'll if you say, well, I've owned this house prior to 1935 this well, although it's not on your records, I'm submitting a claim saying it existed prior to 1935. Well, we'll come back and we'll evaluate the historical accuracy of that claim or viability of that claim. Again, we're not water rights CSI, right? We're not going to do a huge in-depth investigation, but we're going to say, okay, it seems to make sense. It kind of gets me past the 51% point. The propensity, or the information is just kind of tilts me over onto the side of agreeing with you, and so we will make that recommendation, and we'll get all those recommendations, and we'll file what's called a proposed determination. We issue that with the court. We also send notice out to the individual water users, and we hold a public meeting. And so in that proposed determination, it will show the owner of record, or if it's a pre-statutory claim, whoever the claimant is. It will show the CFS or the flow rate of the water right, how many acres or how many cows or how many houses it's for, and where it's used. And it'll have all those facets that we discussed earlier in it in one big book. And we'll have a public meeting to kind of go over that. And then if you don't like what we recommended to the court, you have an opportunity to file an objection. And these are and when you file an objection, again, we are obligated to resolve that objection. And we either resolve it through kind of coming to a mutual agreement through a stipulation of some variety. If we screwed up, we have no problem saying we screwed up and fixing it. However, if it's something we just disagree with, we may choose to litigate it, and we may go to court with you. Again, once we have resolved all those objections, we petition the court to issue a interlocutory decree or a decree on that book, in essence saying this is what the water rights are. Those water rights that were claimed that have been fallen out of use, those are recommended to be forfeited. And so that's kind of how this gets wrapped up into one legal proceeding. It sets forth those that are still good, gets rid of the bad ones, and then we drive on and we move on south down the valley. So here's the boundary of the West Murray Subdivision. Now you'll notice this map looks kind of like the one you received in your notice, except there's a lot of purple little dots. Well, all those purple little dots represent points of diversion, most likely wells in our book. And we did get a map printed out for this, right, Jeffrey? That should be out there afterwards. No, I thought we had a big one printed out. Do we have one out there, Sam? Yeah, big map. Okay, so following this, we print out a large scale map so you can actually identify your house and you can see where these dots are located. Again, I'll show you the interface where you can get online and look at the same thing, but we do have a couple physical large scale maps of this with aerial imagery and a little bit more ease of picking out where you live. And so in this area, we have 374 rights of record. So those are all the rights we know of upstairs, right? Most of them are wells. And just by way of information, we sent notice to roughly 9,500 people of this proceeding. And you can see how many people showed up tonight. Hopefully there's people viewing online and took advantage of that. Here's some issues and anticipated timeline. We talked extensively, or a little bit, about the title issue of water rights not having current ownership on, or the ownership on our records doesn't reflect the ownership of the water rights. We encourage people to be mindful of that. If they want to update title to those water rights on our record, and so that they're the owner of record, there's a separate process for this. That shouldn't prevent them from filing a claim. They can still file a claim as a claimant. However, until they go through that other process, they won't be recognized as the owner. Now, you might ask, what benefit does it get me to be on the owner? You know, why do I want to be the owner of record? Well, if you have a well, you have to be the owner of record on our records before a well driller can renovate that well, or you can file a change and move that well to a different location, or sell that water right. So there are some advantages and some incentives to update ownership. Also, a little bit more of a history lesson, you know, back in the late 30s, early 40s, you know, World War II was going on. There weren't a lot of engineers available because part of the appropriation process, if you apply for a new water right, you have to file a proof on it. And filing of a proof requires a proof map to show where the point of diversion or the well is and where the beneficial use is. Well, there was kind of there weren't a whole lot of engineers available to do that in the 40s. And so the legislature kind of placed a moratorium on that requirement, in essence, and said, for a small amount of water, you don't need to file a proof. We call those no proof required. Now, that's great, and it was great. It was obviously needed. The problem is that when they filed these applications, the locations of those wells weren't very well described. They weren't defined accurately because there was no reason to have a surveyor or an engineer come in and plot them on a map somewhere. And so when you look at these dots on the map or on our interface, you have to take them with a little bit of a grain of salt for a number of reasons. Sometimes they're a result of these no proofs required, and that the well was, you know, they are looking at a USGS map, a 1 to 50,000 scale map, and saying this is where my well is. And so you can imagine there's probably some discrepancy in where it's actually located. And so you got to kind of, again, take it with a grain of salt when you see that this well is plotting in the middle of your doghouse or something like that, because you know, as best the technology we have is great, but it's garbage in, garbage out. And if we have a bad point in, regardless of how accurate our GIS interface is, it's still going to plot a bad point. And that's part of the adjudication. We hope to update that to actually get the correct location in it. Anticipated timeline, the notice to file claims will be mailed out from here on March 30th. So and that's usually, we do those on Fridays. So usually people will start getting those notices on the following Monday or Tuesdays. The 90-day period to file claims begins on the day it was mailed, which puts June 28th as the last day to file a claim. In September, we will publish the list of unclaimed rights. We'll hold another public meeting. That's when the 90-day period to file an objection to the list of unclaimed rights begins. And in December, that 90-day objection period will conclude. Now we kind of fast forward to around February 2020. In an effort to try to get our arms around a lot of the complex water rights issues, it's going to take us a little bit longer to formulate what that proposed determination is. Now, that's not really, it's not because your water rights are very complicated if you have a well or something. It's really large water companies in Salt Lake City and some of these historic exchanges that we're trying to unwind and really get a good understanding of how these interact and operate. So the proposed determination probably won't be published until after February of 2020. And then in May of 2020, assuming that that is when it's published, the objection period will conclude. Again, the 90-day objection period begins when we send notice. Now that, yes, ma'am.
The notice to file claims, is that a paper that's going to be mailed out and you fill that paper out?
Yes, so our question is, what does the notice to file claims look like? Yeah, it will have a letter saying this is your notice with a notice date on it, and then it'll also have a claim form. And we encourage people to come in and we'll help you fill that out if it's not clear how to do so. Yes, you can come here or call us on the phone. We'll try to walk you through it, but it's easier usually if people come up and show us. We can go onto our computers and we can see where your property is, and we can see if you don't know what your water right number, we can try to identify what maybe that water right number is you're trying to file on and make sure it lines up so that you're not just filing a blank claim in the dark somewhere.
We're at here, where we come.
So her question is, where at here would you come? Well, you come into the front lobby and you say, I'm here for water rights. We're on the second floor on the west end of the building, in the old building, the old brick building. So just right over here on the second floor. And they'll direct you if you get lost. So, do you have another question? Yes, sir. Should he bring his deed? You're certainly welcome to. We won't be updating title as a part of this process. If it provides more information, we encourage people to do that because it might shed some light on who the historic owner of record for a water right was, and if that deed lines up with that historic water right, we know that that's the water right you're claiming. So it may provide some additional information. If you can bring it, great. If you can't, we'll figure it out. Yes, sir.
Hypothetical question, if I have a water share here in Salt Lake County, can I transfer that water share to another county?
So his hypothetical question is, if I have a water share here in Salt Lake County, can I transfer that to a separate county? So let's be clear. Are we talking about a water right or a water share? Okay, water right. So water right, yes, there's these things called change applications, right? So if you have, but it depends on the hydrologic connection of what water you have and where you're going from and where you're going to. And there are certain policies in place that would prevent that. You know, obviously, if it's not hydrologically connected, it's hard to say that it's the same water. You're just pulling it from a different place. So there are some policies, but it's not impossible. Okay. Yes, ma'am.
So we fill out the paper, the claim form, and bring it here? Or
Yeah, so once you fill out the claim, you can file it with our office. So you just file it here. It's no charge. We just take it, date stamp it, and we put it in our pile to evaluate later. Or you can file it at the district court. We think it's easier to do it here since you're already here. Some people prefer the district court because they think state engineer is somehow biased or something to that effect. But a claim's a claim, regardless of where you file it. Can you mail it in? Yes. You can. I would just be careful. You know, if you mail a claim in, you just want to make sure that you touch base with us to ensure that we received it at some point. We've had issues in the past where people have claimed that they've mailed a claim in and we've never received it. And we don't know where the disconnect is. So we just ask that either you can do it with certified mail or you can do it, just call us and ask us if we received anything. You know, kind of stay on it and don't do it on the last day that it's right. We need it here by the last day, not mailed from your house. Yes, sir. Can you email it? If you can scan it, sign it, or you sign it, scan it, and email it, we'll accept that as well. Yeah, so the best way to do that is to do that on our that email address. Then I'll show you here in a second. That way I know, at least I see it. It comes through me, and I get it to the right team. But yeah, certainly. Yes, ma'am.
so about the district court, where is the district court?
The district court's at the Matheson Courthouse. It's the Third District Court in Salt Lake City. Again, they've become a little bit more familiar with this. So if you go in to file a water user's claim, they'll know what you're talking about. It used to be in the past they had no clue. The clerk had no idea. But we're doing so many of these now that they're a lot better versed. So let me finish this slide. I think we're done, all right? And then you guys can hang out. You can take off, and I can kind of walk you through our interface, all right? So obviously a big question is, will I lose my water right? So the answer is, if you're using your water right in conformance with how the law operates and how it is on our records, you have nothing to worry about. You just need to make sure you file a claim within the prescribed time frame. Those without a water right of record, meaning you have a well and maybe no one has filed a claim on it previously or no one's appropriated it, you need to make sure you bring that claim forward during this process. Otherwise, you will lose the ability to do that moving forward. You'll be barred. And again, those of water rights that have fallen out of use for 7 years or more could be potentially forfeited by the court. Okay. So who do I contact? That's me at the top. Gary Brimley is my engineer. He's kind of my deputy. And then John Bream is actually going to be leading the team out there. So he's kind of your boots on the ground guy. If I get any emails, that's John back here. Wave John. If I get any emails with claims or questions, I'm just going to forward it to him because I have a lot of other subdivisions we're working at simultaneously here. And this presentation will be on our website tomorrow. I'll get it uploaded tomorrow, as well as you'll be able to view this online on our YouTube channel. Currently, you should be able to. I'm not sure how long it takes to get processed. Paul, immediately? Available tonight. All right, so let me just look, see if anyone's emailed a question in really quick. Doesn't look like I've received anything. Are there any other questions from the body here before we kind of open? I'm going to get online and show you some of the cool tools we have that will help you determine what water right to file on, or maybe you can play around with. Anything else? All right. Yes, ma'am. Yes, this is the email I'd prefer that people use if they, again, make sure it's signed, all right? And then if you want to sign it and scan it and email it to us, we'll accept that. We want to make it easier. We're trying to develop an interface that allows people to file claims online. It's just still in production right now. We haven't gotten to that point yet. So, all right, let me hit up the internet here and we'll show you our website. All right, let me just fix the resolution on this so you can see the entire screen. Stand by for 1 second. Okay, so our website is www.waterrights.utah.gov. This is the home page, okay? Now, I'm trying to work with our technical guys to get a link to the map right away, but this is the best we got. So, and I'm going to show you two different features that may be important to you or maybe not, but let me just kind of walk you through it. The first is just our map interface. So if you go to data, a drop down will appear, and you go to GIS maps, okay? And in the upper left-hand corner, water right maps. And then just go to the first link, so Esri map interface, adjudication areas. And that'll bring up a map of the entire state of Utah, and you'll see it has all kinds of purple spaghetti all over it. Those are our different adjudication subdivisions, and you can see a huge mass of purple in the Salt Lake Valley, and that's where we're currently functioning. So let's zoom in a little bit. And let's keep on zooming in until we get into the right subdivision. Right there. Okay, so you see 57-19, that's the nomenclature we're using for the West Murray subdivision. So you'll see that on your notices, you'll see that on your claims, your notice to file claims, et cetera. So that's when we talk about a book or an adjudication area, we're talking about Area 57, Book 19, okay? So let's, we can zoom in as close as we want, but if someone wants to, you can go over to this tab, you see me on the right-hand side over here, you can go to search, and you can select this drop down, and if you just want, if you're not really comfortable and kind of zooming in trying to find where your house is, we can just put in an address. Someone give me an address. 474 East, 5900 South, and I know it's not Salt Lake City, but it's just easier to do this. It'll get us to the same plot spot. So we'll zoom in on there. That look like your house? Or the property that you were referencing? Okay. So the red X just indicates that's the location of the address that we are looking for. What we want to do now is go over here, and you see there's a list of items you can select. What we're interested in, and you can certainly play around with some of those other items, is points of diversion. Okay, and you'll see a couple of red icons with wells in them show up with different numbers. So those are wells for which we know exist that have water right numbers on them. You can see 57-2318 and 57-8006 or 8061. Now again, whether that's where those were really located, we know that they are in this general location. But what we want to do now is, if we want to investigate, maybe whether that's our well or not, we can select the well, and then it'll bring up this little snapshot, and this will tell us the owner of record, which is Wendell and Roxanne Cloward for this particular well. So if you know that you bought the house from the Clowards, then you can probably be reasonably assured that this may be the well that's associated with your backyard. That's you guys? That is you guys? So you are the owners of record for this particular water right. So it looks like it may be kind of skewed to the east a little bit as far as where the well location. It looks like it's plotting on your neighbor's yard, right?
What I've understood is the boundary on the one side of our house, they come one way and then they come the other way, and there was a problem with it all meeting. That's why it's over there.
Okay. Well, at least you're the owner of record on the water right, so you got a smooth path, right? Because assuming that this is the correct address, and we can go to the website. So if we select that link, this is what the website looks like. Now, there's a little bit easier interface that I'm going to go to. So this is what our old website looks like. We're kind of going to a new version. So if we select this link up here, it's probably a little bit more easy to digest, in my opinion. So let's scroll down. So you see your names right there, your name and address. Wendell and Roxanne, your address. This is when it was filed. So this was an application to appropriate that was filed back in 1975. It's had proof submitted and it's been certificated. So it's a great right. We go down here and we see the water uses. So for this particular water right, this is authorized to be used for a 1/4 acre of irrigation. All right. So water use group number, don't worry about that. Irrigation is the beneficial use for 0.025 acres, and then it's located in the southwest quarter of the southeast quarter of Section 18, Township 2 South, Range 1 East, Salt Lake Basin Meridian. If you're familiar with that stuff, if you're a farmer, you're probably a little bit more familiar with it. But that's how we identify the place of use, okay? And then if you just select this, that will take you back to the map view that we were just at, or you can just go back. So this is kind of what water rights look like. Let me show you the old. The old look is fine. It just looks like an old dot matrix printer, right? So it has the exact same information. It's just kind of, in my mind, a little less appealing format. 0.25 acres of irrigation down here in the southwest of the southeast of the same section, township and range, and the ownership information. Its authorized flow rate is for 0.0147 cubic feet per second. It's an underground water well. that is the location that we have for the point of diversion. What this says is it is north 992 feet, west 1529 feet from the southeast corner of Section 18, Township 2 South, Range 1 East, Salt Lake Basin Meridian. So in essence, it's kind of a Cartesian coordinate based off of a section corner. Yes, ma'am.
Can you take a look at mine? I'm not good
You betcha.
at finding that.
So I'm going to go back to the map interface, and I'm going to go back to search, and I'm just going to deselect this so you don't have to worry about that. What's an address for you?
4568 Fox Elder Street.
Does that look right? Okay, so I believe I already have the points of diversion layer on. So in this particular instance, I don't see any water rights of record in your general vicinity. You know, we can zoom out a little bit, but there doesn't appear to be anything nearby, and we can continue to zoom out. Oh, did not mean to do that far. Sorry. Mouse pad versus, but you can see all those red dots all over, those are clusters of water rights, but I don't see anything in your immediate vicinity. So if you have a well, that would indicate that you have a water right that may be pre-statutory, that they need to file a claim. You have a ditch. And so ditches are a little bit different, right? Because the ditch originates way up off of the canyon stream. So the point of diversion for that would look like this little blue icon over here. Okay, that indicates a surface water right. So what's the name of your ditch? Little Brown Ditch. Do you know what the source is? Is it Big Cottonwood or? Okay, so if we wanted to find that, we'd have to trace that ditch back. And I am not as familiar with these ditches. There's one of my staff out here, Ashley, who has mapped all of these. She would know where that is, but we can certainly do this. It may be. So the question is that not considered a share instead of a right? So a lot of these, the water rights associated with ditches were often associated with irrigation companies that were responsible for maintaining the ditch. But in some cases, it was just a bunch of people who had rights and they all just had the ditch. So in that case, you had 10 different people all had their own water right, but they shared the same ditch, versus an irrigation company that had one water right and then had shares to subsequent shareholders. Now, in your case, I'm not sure if you are a member of an irrigation company or shareholder or not, or whether you have a water right on this ditch. Usually what happened is these ditches got decreed as part of the Big Cottonwood Creek decree, and they would have different decree award numbers on them that would line out this ditch has so many acres associated with the users. But let me go back here. So if I want to show more layers, there's all kinds of interesting layers. You can throw up the canals layer. And this is kind of a recent addition that we've done. And it should show, I'll hold my breath here. Isn't that the layer, Mike?
Like you gotta activate that, where it says canals.
Uh-huh.
You gotta click that box and it'll give you a sliding scale. There you go.
Yeah, it should show up. Unless there's just no, sometimes the internet's a little bit slow, but eventually it will show up. But what it will show is all these different canals that cross the valley. Mike, am I not doing it right?
Yeah, take it and pull it to the left.
To the other direction? Okay. I don't think that. I think it's the wrong direction. I just think it's this slow. Oh, there we are. So you see all the red and blue. So let's go back into where you were. So I'm going to go back here. I'm going to zoom into that address. And maybe just back it off a touch. See, it doesn't show. Are you talking about that ditch that runs right there? And so, in essence, in theory, we could trace this. And let's see if we can trace it. I don't want to waste anyone's time, but you kind of trace this to see where it ends up with respect to Big Cottonwood Creek. And in theory, so you can kind of see, you can probably keep on tracing. And the red indicate piped segments, so we'll just keep on doing our best to see where this ends up. And one of the problems is a lot of this information is piecemeal. And so you can see that it appears to terminate there. Obviously doesn't. It obviously goes somewhere or connects into somewhere, but the information is just not complete. So I'm not sure where it goes to, but I presume that at some point it links up with Big Cottonwood Creek, and there would be a point of diversion with a blue icon that would indicate where that originated from. And we can also, if it's an irrigation company, we can do a search on the name for the irrigation company. What was the name of it again? Little Brown Ditch. Yeah, I am not familiar with that, but I'm certainly, if you came in, we'd be able to spend more time and kind of fish that out. So, yeah. Are there any other questions? Yes, sir.
Okay, so my water rights is my grandpa's name and that street address. So what do I need to do to get it into my name?
Get in your name. There's a process called a report of conveyance. So if I go back to our homepage, okay, and that's different than what we're doing, but I'm going to show you kind of where to go. So if we go to our homepage here, and you go to Programs, you go to Title Transfers, and just select that link. It'll kind of give you the process that you need to go through. So the long and skinny is you need to hire a title professional that will come in. And so a title professional is either a title professional, a surveyor, an engineer, or an attorney. And they're the ones who are authorized to prepare this report of conveyance. In essence, what they do is they go back to your grandfather and see that he owned this land at some point, and he also owned the water right. And he had this unity of title between the land and the water right. And again, assuming that the water conveys with the land silently, they walk that chain of title until it lands on you, and they said, all right, there's a chain of title from your grandfather to you of this land, and there's nothing in those deeds that explicitly convey the water to someone else, so we're going to bring it forward. And then they prepare this form, and they file it with us, and we update your name on our records. So, but title professionals know all about that. If you're curious how to find a title professional, at the bottom here, we have a list of them. Again, attorney's probably a little bit more expensive. Title professional is probably a little bit more lower end and do the same thing. So that's my recommendation.
So do I fill out a plan and say, hey, I got this well?
Yeah, you would still do a claim, even though it's you just file it as yourself. And what we do is we say, all right, you're not the owner of record, but you're a claimant. And so we're going to treat it the same. So to us, it's treated the same. We look at it as though it was your grandfather who had filed the claim. We simply just don't update the title in our records to the claimant information. But to us, as long as someone can demonstrate that it's being used in some capacity, that's all we care about. We do care about title because we want people to have accurate information on our records so we can send the appropriate notices. But for the most part, we're just interested in people making sure that, hey, they're using their water and they've made a claim. So you'll be known as a kind of a claimant. We call it a claimant claim, even though it's kind of a little redundant. But that's kind of the terminology we use. Are there any other questions? Oh, yeah. Let me check my email. I got an email from you, Paul, but outside of that, I think that's about it. All right. Without any further ado, let's go ahead and adjourn this meeting. Thank you.